how and why you might consider using a transfer on death deed. I'm Taylor Kaspar, owner and managing attorney of Legacy Estate Planning, where we help families make empowered choices about their finances so they can leave the legacy they truly deserve. So here's how and why you might consider utilizing a transfer on death deed as a part of your overall planning for passing assets from one generation to the next. First things first, what is a transfer on death deed? Well, here in Minnesota, a transfer on death deed is a form that you can procure from the Minnesota Conveyancing Blanks and fill it out simply stating that you desire to leave your property to a specific person or a couple of people upon your passing. Or if you're married, your property can pass upon the death of the second of you and your spouse's passing. So a lot of people love to use these for various reasons. Probably the biggest one is because a transfer on death deed avoids probate. But we're going to get into why to use it and how to use it here in just a moment. And then after we finish those two parts of the discussion, I want to talk to you about some perils and pitfalls of using a transfer on death deed, because of course, nothing is ever as shiny and bright as it seems. Why to use a transfer on death deed? Well, a big goal of a lot of people when they're talking about their planning for what will happen upon their death is they want to avoid probate. Probate is that court process that you have to go through to determine who gets your stuff, how they get it, when you die. And a lot of people don't want to put their family in front of a court. They want to skip over the court process. They want to make the administration as easy as humanly possible for their kids or for their loved ones or whomever they're leaving their estate to when they're gone. So one of the ways that you can avoid probate is by utilizing a transfer on death deed for your real property. So that could be your home, a second home, a rental property, a cabin, a piece of vacant land that you rent out, farmland, anything that has a deed that is recorded with either the Registrar of Titles or the county recorder can be passed by transfer on death deed. So that would help you keep it out of the probate court, because upon your passing, all your heirs or whoever is getting the property has to do is fill out a subsequent deed-like form called an affidavit of identity and survivorship, swearing that they're the person entitled to receive the property, and they file it with the court for the grand sum total of $46. Like, how much easier can you get? So a lot of people are becoming more and more aware of that, and they're like, hey, I'd like to skip over probate and would like to make this easy for my family, so I'll go ahead and record a transfer on death deed. And that's exactly what they are designed for. I would say that one of my big tips for using a transfer on death deed is that they are really effective when there's either a small amount of property, like maybe we only have the house, or if the transfer on death deed is transferring the house when there's a larger estate to a trust that's going to manage assets and property for all of your heirs and all of your beneficiaries when you're gone. Another reason people choose to use a transfer on death deed, along with the fact that it skips over probate, is that when there's no probate, your estate administration is much more private. When you have a probate, everything gets published in a legal newspaper, and the probate itself, all the documents that are filed into that probate, are public record. So you could go on the mincourts.gov website and you could type in somebody's name who's died, whose assets went through probate, and you could read everything about that probate. You could read their will, you could read the petition. If there's a fight in court, you could read all the documents about the fight. And a lot of people want to skip over that. So when they're skipping over probate, that's a goal, is to maintain that privacy and keep things out of the public eye. So that is a reason for probate avoidance, and hence using that transfer on death deed. Now let's turn to the how to use a transfer on death deed. Transfer on death deeds are actually a published document that you can download and fill in from the Minnesota Conveyancing Blanks. So if you were to Google Minnesota Conveyancing Blanks, transfer on death deed, your search results should turn up the appropriate form for an individual to transfer a property to an individual grantee, that is the person receiving the real property that we're talking about. So you could download that form and you could fill it out saying, I, Taylor, am going to transfer my property on my death to my 4 children. And then I would fill in their names. I would fill in my marital status. I would type in the legal description of the property that I want to transfer so we can make sure we're identifying the correct piece of property. And then I would transfer either part of my ownership, whatever I own right now, or I could transfer all of my ownership in that property. Say I gain an additional parcel if it's farmland or an adjoining lot or something like that. Or say I give away a piece of my interest in the property over my lifetime. I could transfer whatever my interest is at my death onto my next generation. So it's a very simple document. You fill that out. For it to have any sort of legal effect, you must record it with the county in which the property sits. So you might have to drive down to your county office with the appropriate filing fee, which right now at the time of this recording in the state of Minnesota is $46, and take it down there and ask your county recorder or your registrar of titles to record that document for you. And once it's on the county books, it is legally effective. And then, like I mentioned a little bit earlier, when you pass, your heirs and your beneficiaries, the people receiving the property, simply need to go down to that county office or mail it in, pick your poison and say, hey, I swear in an affidavit that I am the person who is entitled to receive this property. Record it with another $46, and they will actually get a deed to that property evidencing their ownership. Is a very slick and easy tool for small estates where maybe the only property passing that would be probatable is that real property, or they're also very useful when you're transferring property on death into a revocable living trust that has now become irrevocable by reason of death of the person who made the trust, the trustor. Here are some pitfalls that we see when people utilize transfer on death deeds. Become a very difficult situation if you transfer a property on death to more than 2 recipients. So say you have 2 children and you want to transfer the property on death to your 2 children in equal shares. Great, that's probably fine. But say you have 3, 4, or 5 children, you might be running into some pitfalls by transferring one singular piece of property to 5 different people. Now you have 5 people that need to sign off if they desire to sell the property. And because of our marital laws here in the state of Minnesota, if 5 people own the property, but say all 5 of them are married, all 5 of their spouses would also need to sign off on the sale of the property before that sale could be legally effective. So you might have 10 different people that have to sign off on that deed before the property can be sold. And that can cause a lot of fighting and a lot of other issues that could come up upon transferring to all of those people upon death, and then trying to sell it in the future, transfer, or decide who should pay for what. It just can become too many cooks in the kitchen. Another peril or pitfall I see with transfer on death deeds is a lot of people incorrectly believe that a transfer on death deed will escape the estate recapture upon the passing of a person who received medical assistance for long-term care in old age. So if you do a transfer on death deed, but you received medical assistance for long-term care, medical assistance can actually come in and place a claim against the property. Then when you try upon the transfer on death deed with that affidavit swearing that you should receive the property, the county could ask you for a medical assistance clearance. So they could say, hey, are you sure that medical assistance doesn't have a claim on this property? And you'd have to enter in some paperwork for medical assistance to run a search to determine whether or not they have a claim. And if they come up with a claim, then when the property is transferred, they can demand payment of the claim, or that, if too much time passes, that the home be sold to satisfy the money that they spent on the person who passed away and on their medical assistance for long-term care. So there are some times where using a transfer on death deed can be great, and other times where you might want to think a little bit harder before putting a transfer on death deed in place as the only form or method of planning for your estate and for your passing. If you found value in this video, or if you want to know more from us, then make sure that you like this video, subscribe to this channel, and turn on notifications so that you never miss any updates.